Policy. I'm Joe Della Penna, as you can see, and I'm moderating the panel, so I will keep my remarks brief. Most of you probably already know that worldwide, water governance is being challenged at all levels, from the local all the way up to the international, by a number of forces that are at least mostly beyond human control. The most obvious one is a growing population. We've expanded human population on the planet since 1900 from about 1.5 billion to a bit over 7 billion. And it's continuing to grow, although at a slower pace. But we also have vast changes in economic activities, and that implicates vast changes in the amounts of water required. At the same time, we are experiencing, and it's just beginning, global climate disruption. And that unsettles historic patterns of water availability. Some places will have more, some places will have less, but all of this combines together to pose very significant challenges to law and policy relating to water. And if law, so our topic today, as indicated, water challenges for international law and policy. Traditionally, a panel with a title like this would have focused exclusively on transboundary issues. That is not entirely possible today. Increasingly, international law actually speaks to some extent, and that's debatable, highly debated, as a matter of fact, among people, to what extent, to water issues at the national and perhaps even local level. The most obvious example of that is the human right to water, which would have little effect if it were only to be realized at the transboundary level. It has to be within the nation. A good deal, I would argue, of international environmental law and international human rights law also comes into play. All of this was summarized, again, subject to debate as to whether it was summarized accurately or not, but it was summarized in a project in the International Law Association, a joint sponsor of this meeting, as you know, called the Berlin Rules that were on water resources that were approved in 2004. And if I was the rapporteur for the Berlin Rules, but I won't discuss them here. But I'd be happy to talk to anyone who has questions about them, and you can obviously find them online very easily. Now, we have 4 speakers today, and I've asked them to speak for 12 minutes each in the hope that we'll have ample time for questions and answers afterwards. Our first speaker will be Steve Mccaffrey, to my right, who is a distinguished professor at the University of Pacific McGeorge School of Law. He served as the primary special rapporteur, there were a series of them, on the drafting of the ILC draft articles that became the UN Watercourses Convention. He also has served as a counsel in water disputes before the International Court of Justice and in other fora, widely published. And his topic today will be water scarcity and security issues in the Middle East. I'm sure you can summarize that up in 12 minutes, right, Steve?
Right, Joe. I would need the whole panel's time, and even then I couldn't do it justice. But thank you very much, Joe. It's a pleasure to be here. Thank you to all of the members of the audience who have come. Joe put his finger on it. We are living in a time of climate change, so all issues of scarcity and security have to be viewed in that context. The Middle East is notoriously water short, but like other regions, the water that does exist is not evenly distributed. Some countries have more, some less. What I would like to do, since I can't cover the whole Middle East in 15 or now 12 minutes, is to focus on 2 case studies. One, the Nile, and the second, water issues between Palestine and Israel. So the Nile Basin is like every other region. Some have more water, some have less. The upstream states, the equatorial lakes states on the White Nile and Ethiopia on the Blue Nile generally have plenty of water, or at least access to it. Egypt, on the other hand, is almost completely dependent on the Nile. So water security for Egypt means no one else developing Nile water resources. This is, in essence, what two colonial-era treaties provide. The 1902 treaty between the UK and Ethiopia, and the 1929 Nile Waters Agreement between Egypt and the UK, both of which, according to Egypt, give Egypt a right of prior consent to any works on the Nile that could adversely affect Egypt. So while Egypt maintains that these two treaties continue to be binding on the UK's successors on the White Nile and on Ethiopia on the Blue Nile, those successors, not surprisingly, dispute this. So this was the background for the first effort to prepare a treaty governing the entire Nile Basin, an effort that resulted in a text called the Nile River Basin Cooperative Framework Agreement, which is a modern agreement negotiated by 9 of the then 10, now 11 states in the Nile Basin. The sticking point, I'll cut to the chase, has to do with so-called existing agreements, that is the 1902 and 1929 agreements. Egypt and Sudan somewhat half-heartedly, wanted the new treaty to provide that it didn't affect the old ones, while everyone else wanted the opposite. Not surprisingly, again, negotiations had been proceeding by consensus, and no consensus could be reached on that point, so an effort was made to bridge the gap through the concept of, you guessed it, water security. An article was drafted recognizing the vital importance of water security to all Nile Basin states, and providing that those countries would not, quote, significantly affect the water security of any other Nile Basin state. 7 of the 9 negotiating states accepted this. Egypt and Sudan didn't. Egypt proposed instead that this clause provide that Nile states agree, quote, not to adversely affect the water security and current uses and rights, Sudan added, and rights, of any other Nile Basin state. Egypt wanted to guarantee its current uses. Okay, well, it takes 6 ratifications to bring the Cooperative Framework Agreement into force. There are at least 6 Nile states that would like to bring it into force. The only thing that seems to be stopping them is this idea of a Nile Basin agreement without Egypt. Something funny about that, except it's not so much that they care about this as that they realize that it'll be very hard to find funding for significant projects without Egypt being on board. So this defines water security in the eyes of both Egypt and the international donor community, except perhaps China, which has been very active in dam building in Africa. Let me turn now to water issues between Palestine and Israel. First, a disclosure. I've been advising Palestine since 1999 on final status issues, including water. The Oslo process was supposed to result in a permanent status agreement at the end of 1999. We all know how that came out. As you can imagine, while water isn't typically mentioned as being among the final status issues, which are usually referred to as borders, security, Jerusalem, refugees, it is highly contentious between the parties and would have to be provided for in a final status agreement if Palestine is to be viable as a state. In a way, this contentiousness can seem odd since Jerusalem actually gets more rain than London. But Israel was highly aware from the beginning in 1948 that to exist as a state, it would have to have enough water to provide for the vital needs of its citizenry and to support a robust economy. Therefore, it took steps over the first decade or so of its existence to control as much as possible the main surface waters it would rely on, the Jordan River and the Sea of Galilee, called Lake Tiberias by the Palestinians and the Kinneret by the Israelis, plus important tributaries coming from Syria and Jordan, such as the Yarmouk. So today, Israel controls the 3 main headwaters of the Jordan, the Hasbani in Lebanon, the Dan in Israel, and the Banyas in Syria, either through the threat or use of force in the case of the Hasbani, or occupation, the Banyas, which rises in the Golan Heights, occupied by Israel since the 1967 war. In 1964, Israel inaugurated its national water carrier, a network of large pipes and canals that are believed to take as much water out of Lake Tiberias as goes into it, and deliver that water to coastal cities in Israel and the Negev Desert to the south. This, of course, leaves the lower part of the Jordan below Tiberias largely a dry bed. But for water from saline springs and sewage pumped from Nazareth that Israel pumps into the lower Jordan just below the dam at what would be the outlet of Sea of Galilee. As a consequence, the river's terminal Dead Sea is dying. Its level dropping precipitously, which in part prompted a World Bank-backed initiative to save the Dead Sea through an engineer's pipe dream called the Sea Dead Sea Conduit, also known as the Dead Canal. This will take Red Sea water through the coastal mountains, down a steep gradient to hydropower and desalination plants at the Dead Sea, lowest point on Earth, of course, producing power to run the desalter and to pump the resulting fresh water back uphill to Amman and Jerusalem. The brine from the desalter will be fed into the Dead Sea, slowly restoring its level, while additional supplies of fresh water will be available for Jordanians who are in a state of water stress, as well as Israelis and Palestinians, albeit at a steep price, as you can imagine. Currently, questions are being raised, actually, about the Dead Canal's feasibility. But in any event, the project does nothing to restore the flows in the Jordan below Tiberias, a stretch of the river to which the West Bank is riparian and to which Palestine, the state of Palestine, should have access, along with the Dead Sea, to which the West Bank is also riparian. All this has been about surface water. There's also important groundwater to be talked about. This is critical to both Palestinians and Israelis. Most of this groundwater is stored in three aquifers underlying the West Bank: the Western Aquifer, the Northwestern Aquifer, and the Eastern Aquifer, Northeastern Aquifer, as they're called in the Oslo II Accords. Very shortly after the Six-Day War, Israel issued 3 military orders that placed under its control all of the water resources of the West Bank and Gaza, at least until relatively recently, because 5 Israeli desalination plants along Israel's Mediterranean coast have come online, producing a total of some 542 million cubic meters of fresh water a year. So until recently, Israel relied on these West Bank aquifers for around a third of its water supplies. Israel's military orders, which are still in force, give Israel control over all water in the territories. It might be thought that the Oslo Accords, which established the Joint Water Committee, would have changed the situation, but on the ground, they haven't. Palestinians in the West Bank currently purchase their water from Mccaffrey, the Israeli water company. There are well over 1,000 Palestinian villages that receive no water through their connections, which means they're forced to improvise by collecting rainwater, although the Israeli military destroys cisterns because they are sometimes built without permits. The result is that the available water for agriculture, industry, and drinking as of 2011 amounts to 646 liters per person per day for Israelis and 133 liters per person per day for Palestinians, which does not strike me as being very equitable and reasonable. In Gaza, the situation is even worse. I hope I have time to say a word about Gaza. Overpumping of groundwater, mainly in Gaza, has resulted in saline and saltwater intrusion from the Mediterranean, and this has contaminated the aquifer. In addition, Israel has cut off the Wadi Gaza, a seasonal stream that flows from Israel into Gaza, has drilled numerous wells just north of the Gaza Strip, intercepting groundwater that would have flowed into the portion of the coastal aquifer underlying Gaza. The Palestinian, in closing, the Palestinian position on water is really quite simple. Follow international law as reflected in the 1997 United Nations Watercourses Convention. This is a treaty to which Palestine has committed to accede. Israel should do so as well. The three other riparians in the Jordan River Basin, Syria, Lebanon, and Jordan, were among the first to ratify the convention. Having all the Jordan River Basin states within the convention would not create more water, but sharing existing water resources cooperatively under an agreed set of rules would effectively do so. Thank you.
All right. As another disclosure, I headed up the legal institutional team for the feasibility study on the Red Dead project, so something else you might want to bring up. Our second, well, you know, there's been some movement on it, but it hasn't been fully approved yet, and it may never be fully approved. I agree with that as a possibility. It's not certain. But in any event, our second speaker is Laurence Boisson de Chazorn, who is a professor on the law faculty of the University of Geneva, former senior counsel of the World Bank, has chaired several WTO arbitration panels, has argued, as Steve Mccaffrey has, before the ICJ. And her topic today is minimum flows in an environmental perspective at the Kishanganga Award, which, as some of you will know, is an arbitration between India and Pakistan. Go ahead.
Thank you, Joe. I was asked, I would first like to thank Don Anton, who is not with us, but he established this panel, and I was asked to speak about the notion of environmental flow. So I looked at the topic and I just thought, my God, what am I going to say about this topic from a legal perspective? And then I looked at a very interesting award which has been given by a tribunal quite recently, which is called the Kishanganga Arbitration Award. And in the context of this award, the notion of minimum environmental flow has been given an important role. Now, I'm going to be speaking of this the notion and then related to this award. If you want to know more about this case, you have two counsel for India sitting in this room, Steve Mccaffrey and Dan McCrow, so they would be surely more able than me to speak about this dispute. Now, what I think is important with the concept of minimum flow is that so far it has not been given much attention in state practice as well as in judicial practice. So there is not much that you can use to interpret the notion from a legal perspective. In the context of the Kishanganga dispute, Pakistan used this notion to preserve its rights towards downstream flows. There was an issue that India would divert some water, building an hydroelectric plant, and Pakistan invoked its rights to have downstream flows for satisfying its agricultural and hydroelectric uses. Now, when the tribunal looked at the notion of minimum flow or minimum environmental flow, it looked at the 1960 Indus Treaty, to which both India and Pakistan are parties, but it also looked at general international law. And this is something I think which is important. I was sitting previously in a panel dealing with interpretation of treaties, and in this context, it's a very good example where an arbitral tribunal has referred to Article 31(1)(c) to give some meaning to some of the words that are used in the context of this treaty. And so the tribunal referred to the principles of international environmental law, to which I will come back to, and said that because of interpretation, the concept of minimum flow should find application and it should be measured according to certain standards. But before I go to what the tribunal added, I would like to first contextualize the notion of minimum flow in the context of the law applicable to international watercourses. And then I will make a few remarks about the meaning of this notion. So the notion of minimum flow finds its place in the context of the various uses of international watercourses. And we know that since the 19th century, the end of the 19th century, watercourses have been increasingly used for irrigation and energy production uses. These uses have involved planned measures as they've been defined by the International Law Commission, which they include physical infrastructures and installations such as dams, water supply pipes, or locks. Now, what is interesting is that when we're speaking of uses, users can compete with one another, so irrigation versus energy production, but also might be irrigation versus navigation purposes, and so on. And the question is, what is the rule of international law which would satisfy and which would find a way to resolve these issues between different uses of a watercourse? And what is interesting is that so far international law has taken a rather neutral perspective with respect to diverging positions in terms of uses of international watercourses. The only exception to this neutral position is the fact that when there are vital human needs which are at stake, as referred to by the UN Convention in Article 10, they should have priority. Now, so what does it mean? It means that states have to look for a mutually agreed solution, and what are they going to be doing? They're going to be referring to the main principles of international water law, which are the right to an equitable and reasonable utilization, and as well as the obligation not to cause a significant damage. Now, what is interesting in the context of these principles, and we all know that, is that more and more environmental concerns have been given an important role in terms of interpretation of Article 5 of the UN Convention, as well as Article 7 of the UN Convention, which are rules of international customary law. And in the context of the interpretation of this principle, I think that it's interesting to see, and that is why, what in fact the tribunal did in the Kishanganga dispute. It placed the minimum flow in the context of the reference and interpretation to these principles. So what does it mean? It says the understanding behind the concept of minimum flow is that there is a need for sustainable management of natural resources. And if you speak of sustainable management of natural resources, you need to take into account this notion of minimal environmental flow. Now, looking at treaty practice, as I said, you don't have many reference and definition of this notion. So it's interesting to see that, for example, the Treaty on the Lesotho Highlands Water Project referred to the notion of minimal flow. That has been also the case of the 1995 Mekong River Agreement, which referred to it. The Columbia River Basin also, as well as a recent treaty, which I think is of also importance in terms of water development, which is the Water Charter of the River Niger Basin. Now, when you look at these treaties, what I think is important is that for the time being, that the notion of minimum flow was looked at from the perspective of human needs, the need to have a certain amount of water to satisfy human needs. And that is important, and in fact, you have some judicial practice with respect to the satisfaction of human needs in accordance with the notion of minimum flow. And if you refer, for example, to the Lake Lanu decision, you will find that the tribunal alluded to the notion of minimum flow. It's also interesting to be looking at the decision of the International Court of Justice in the Gapshikovo-Najimaros case, where the court seems to have linked the concept of human needs with the concept of minimum flow. And it looked at it when, in the perspective of the argument made by Hungary, that there was an issue of ecological state of necessity, and there was an issue of protecting the aquatic ecosystem. And the court said, and I'm going to quote, "With regard to the lowering of the riverbed downstream of the Najimaros Dam, the danger could have appeared at once more serious and more pressing, insofar as it was the supply of drinking water to the city of Budapest which would have been affected. So there it was with respect to the notion of human needs. Now this is interesting because that has been the perspective so far which has been linked to the notion of minimum flow. Now in the Kishanganga award, for the first time we have a tribunal which has looked at the notion of minimum flow from an environmental law perspective. And it has looked at it from the perspective of the development of international law, from the perspective of the development of international environmental law since the 90s. And the tribunal, in fact, is referring to the development of this body of law. So 3 points that I would like to make with respect, and that will help me to conclude this presentation. The first point is that the tribunal recalls that the notion of environmental minimum flow is legally enshrined in the principles and rules of international environmental law. So that means that there we have an issue of interpretation of the norms and equitable and reasonable use of a water course, which should be interpreted in the perspective of international environmental law. Then, what is also interesting is that the tribunal referred to the pulp mills case, in which the International Court of Justice stated, and I quote, "Due diligence and the duty of vigilance and prevention, which it implies, would not be considered to have been exercised if a party planning works liable to affect the regime of the river or the quality of its waters did not undertake an environment impact assessment." And that's, I think, another point which is of great importance, is that the tribunal said that the notion of minimum flow should be considered in the context of an environment impact assessment. And that it means that if you plan a measure and you have to conduct an environment impact assessment, among the possible impacts, you have to take into account the concept of minimum flow, and you have to give it a meaning. Entering into this room is the president of this tribunal, so it's quite impressive. So I'm speaking about the tribunal and in front of the president of the tribunal. So this is, but I was only praising this decision. And but the point I want to make is that it's interesting to see how the tribunal has linked sort of the traditional law applicable to international water courses with the development of international environmental law, and how the tribunal has linked it with reference to decisions rendered by other tribunals and courts. So this judicial dialogue with respect also to the evolutive interpretation of the law applicable to international water courses. Now, so this, I think, is important, and the tribunal also has stressed the fact that economic development with protection of the environment should go hand in hand, and that means that there should be a minimum flow. One thing I would like to say in conclusion of this presentation, where I think that the tribunal has really put forward a very important concept, is that the notion of minimum flow in the context of the Kishanganga dispute was looked at from an upstream, downstream perspective. But I think that this notion should also be looked at from a downstream, upstream perspective. And I'd like to refer to what Stephen Mccaffrey has said about the no harm rule, when he said that it's a notion, a two-way operational concept. I think that the notion of minimum environmental flow is also a two-way operational concept. So that means what? It means that whatever is the geographical interstate relationship with respect to the management of an international water course, there is a need to protect the environment. That is what I've called the environmentalization strand in the protection of water courses. And one aspect of this environmental protection of a water course is the taking into account the protection of a minimum flow. Thank you very much.
Wow. Remarkably, our first two speakers each came in at exactly 12 minutes, so there we go. Our third speaker is Gabriel Eckstein. He is a professor of law at Texas A&M University School of Law. For those of you who aren't familiar with the A&M formula, it's agricultural and mechanical, I think. Yes. University. He's on the executive board of the International Water Resources Association, International Association for Water Law. And he directs a web-page-based International Water Law Project, and his topic today is water as an economic good.
Thank you, Joe, and I want to thank Don Anton and the ILA ASIL coordination effort to having invited me here and having organized this panel. This is a really fantastic opportunity. I want to first say that as it would luck would have it, I do have PowerPoint slides, but obviously we don't have PowerPoint capability here. That was my mistake, not informing the powers that be that I would like to use PowerPoints. I clearly do not have enough copies, so for those of you that were adventurous enough to sit up front, I will, Valentina, if I could ask you to just pass this back. If you do not want a copy, please pass it back. If anybody wants a copy of the slides, feel free to ask me afterwards. I'm happy to share those with you. As Joe said, what I'm going to talk about is water as an economic good and the implications that might have or could have, does have, on freshwater resources. And the questions that I'm particularly interested here is what implications of a state importing water-intensive products from elsewhere what implications that might have for conservation, for water conservation in their home nation, and whether this kind of trade really assists in global water savings, or are there some consequences, maybe negative, hidden consequences that we should be aware of. So I'll be talking about first a little bit of background, and then get into examples of water as an economic good, then talk about the trade implications, and then give you just a few thoughts on what I think is the way forward. So first of all, as you all know, water, there's a tremendous demand for water, and it's growing at exceptional rates. We have population growth, we have development expanding at considerable speeds around the world. Annual global freshwater withdrawal in 2010 was approximately 4,400 cubic kilometers. I'm not even sure what that means. That it's just such a monstrous size of water. And it's expected to grow approximately 10 to 12% in the next decade. So, and it's expected to continue growing at a rapid pace. As most of you probably know, 70% of water withdrawals are applied to agriculture, 20%, these are approximate numbers, go to industry, and 10% go for domestic use. But in the past 100 years, as the world population has tripled, water use for human purposes has grown sixfold. So tremendous growth in the extraction of water and the use of water around the world. And as a result of this, we've had a growing middle class, not just in the United States, but also in India and China and the rest of the world. And all of these people are demanding more things. And most of those products and items, whether it's food products or automobiles or any kind of iPhones, they do require water. There's a water component in the production process. The result of this growing demand is that we've had tremendous stress being placed on freshwater resources globally. I'm just going to state some of the statistics. I'm sure you've heard these. Nearly 900 million people around the world without access to adequate clean drinking water. In 1998, 31 countries faced chronic water shortages. By the year 2025, that number is expected to, the number of countries is expected to rise to nearly 50, affecting somewhere around 1/3 of the world's projected population. If present water consumption trends continue, the UN has estimated that by 2025, 5 billion people will be living in areas where it will be impossible or difficult to meet basic water needs for sanitation, cooking, and drinking. So there's been tremendous water pressures or stress being put on existing water resources. And as a result of that, governments and populations and people have been seeking solutions. And in many cases, they've been looking to the market as a potential solution for this. And I don't want to get too much into the debate of whether water should be an economic good or not. The basic argument you have on the pro-market, pro-economic side is that water-abundant countries can use their abundance to export water-intensive products and crops and so on, and water-scarce countries should protect their domestic water resources and import those products that are maybe more efficiently being produced in water-abundant parts of the world. But not everybody quite agrees that this is a typical market analysis and that the market can solve these water resource issues. And in particular, human rights organizations, but also environmental groups and other groups, other organizations have opposed viewing water as an economic good for various reasons that I think some of you have heard. I don't want to get too much into this. What I do want to say is, for good or for bad, I think that ship has sailed. Water is being treated right now. The reality is it is being treated as economic good, and I'm going to give you 3 examples: bottled water, bulk water sales, and virtual water. So, example of bottled water sale, I think it's hard to debate against the idea that water that's been extracted, packaged, bottled, processed, and being put into the market is not a good in the market, a product in the market. And in fact, it's been recognized under NAFTA that water in the bottle, once it's bottled, is a product that is subject to trade regulations. Consumption over the past 30 years of bottled water has grown by an average of 12%. In the U.S. alone, the annual sales in 2012 was nearly $12 billion. It just seems undeniable that water in the bottle can be considered, should not be, or is not being considered as an economic product. Let me move on to water, to bulk water, because we don't always consider bulk water as actually happening, water in large quantities being transferred across borders, but in fact it is, and it has been for many years. I'll give you just a couple of examples. Singapore, for the last 60, 70 plus years, has been buying nearly half of its water from Malaysia on a series of contracts. They've been really reducing their import of bulk water in the last dozen years or so, but they are still somewhere in there around 40-45% of their water use comes from Malaysia. Lesotho Highlands Water Project, water flowing from Lesotho to South Africa, is another form of water sale. Along the U.S.-Canada border, there's at least a dozen small-scale examples where cities on opposite sides of the borders have contractually agreed to deliver water, either from U.S. to Canada or Canada to U.S. And these have been operating, some of these have been operating since the 1920s or 30s. They're similar, even less official, less formal on the U.S.-Mexico side, where there's handshake agreements for water transfers. And there's quite a few other examples. I'll note Turkey is now in the process of constructing a submarine pipeline from Turkey to Cyprus. So this is in the works. It was supposed to be operational sometime this year. I don't know. I haven't checked on the latest status of this. So another example of bulk water being traded, being sold internationally. The other example is virtual water. This is a term that I think Tony Allen coined in the early 1990s, referring to water that is required for the production of mostly agricultural commodities, but really any commodity. The water that it takes to produce that product, that's what we're calling virtual water, because when that product is being traded internationally, sold internationally, that water was used, and therefore that water, in a sense, is being traded virtually. In the period of 1996 to 2005, the global volume of international virtual water flows in relation to trade in agriculture and industrial production averaged around 2,320 cubic billion meters annually. And I mean, these are just numbers I just have a hard time understanding and trying to figure out how many zeros you have to put on there. But the idea is that so much water is being traded internationally, and so I'm just left with at least having to accept the reality that water is being considered a commodity, for good or for bad. So let me just touch on the trade implications, because there's, I think, pretty significant implications that are not always considered in this. So first of all, on the positive side, there have been quite a number of studies done that, in particular, in terms of virtual water, I don't have any and bottled water with me. But on the virtual water, that the savings from these commodities, or particularly in agricultural field, has been somewhere in the order globally 4 to 9% water savings on a global level. And if you look on a country level, certain countries have seen an even greater increase. And what we're comparing here is the ratio of net water savings in terms of how much water we used in the product in that exporting country in relation to how much water was not used in the importing country. So Mexico, the estimates are nearly 70% water savings for those particular products. In Algeria, almost 200%. And in Japan, nearly 450% water savings by the mere fact of not using their domestic water resources for the products that they're importing. Now, that's on the positive side. On the negative side, there's considerable implications here. One is dependency. The countries can become dependent on that other country for those water resources. This raises national security issues and also complacency. Countries becoming accustomed to obtaining that resource, that product, that substance that needs so much water, and not having a backup in the event of market failure or in the event of that the exporting company, for whatever reason, decides not to export those products with that virtual water. There's also particular issues that are important for the exporting country, and one is the increase in water demand, the decrease in water availability for environmental purposes, and there's quite a number of problems under the GATT, which I'm not going to get to because of time constraints, but the idea that if you actually consider water as an economic good under the GATT can really constrain a country's ability to protect its water resources because of the anti-discrimination considerations under these trade agreements. So in terms of looking forward, where I think that we need to go, I think one of the things that we have to do is to just recognize that water is different. It's just different from any other substance or product or aspect of society. And because of that, maybe Edith Brown Weiss's suggestion of water as a common concern of humankind might provide us some of the normative opportunities to address these trade issues, which I think can have a really serious negative impact on global water resources. The other points is to capture the true value of water in terms of economic, but not only economic, but social and cultural values of water in the analysis, in that economic analysis. And lastly, maybe we need to exclude water explicitly from the GATT and NAFTA and some of these other trade agreements. So thank you.
Our fourth speaker today is Georgia Kaiser, who is a postdoctoral research fellow at the Water Institute of Gilling School of Global Health at the University of North Carolina in Chapel Hill. And her research focuses on the international intersection, if you will, of health and development. She's done research in the Dominican Republic and Honduras, and her topic today is human right to water and sanitation. We'll see if she has any answers for some of the questions that Gabe raised. Thank you.
Thank you, and thank you for the invitation to speak. I actually had this great PowerPoint presentation for you all with lots of colorful photos of people without access to safe drinking water and sanitation. But I realized when I got here that I wouldn't be able to give it. So I'm going to sort of talk a little bit off the cuff. But that's why I was furiously writing as I was sitting here. So the human right to water and sanitation. I'm going to speak briefly about the evolution of the human right to water and sanitation, and then about some of the obstacles and opportunities in its implementation. So I'll do that by briefly speaking about the global health problem that this human right addresses, and then give you a short overview of the evolution of the human right to water and sanitation and how this human right to water and sanitation addresses some of the current critiques of the Millennium Development Goal for water and sanitation. And then I'll speak briefly about some of the research that I've been working on with colleagues at the Water Institute at the University of North Carolina at Chapel Hill, on the implementation of the human right to water and sanitation and some of the obstacles and opportunities that exist. And that research was recently published in the Journal of Water Policy, the Journal of Science and Engineering Ethics, and the Journal of Science and Engineering Ethics. So you can actually access that. So the human right to water and sanitation is addressing this global problem. 2.2 million deaths from water-related disease every year. 1.6 of these deaths are from children under 5. It's the second leading cause of death in children under 5 after respiratory infection. So these have large-scale social and economic costs. And to prevent these diseases, we know that there are environmental health interventions that can address them. One is access to sufficient and safe drinking water and sanitation that is sustained over the longer term. And the other is through hand washing, and hand washing with soap, so hygiene. And in fact, hand washing with soap is a very low-cost environmental health intervention that decreases diarrheal disease at a greater rate than any of these others. So adequate access to water, sanitation, and hygiene can decrease disease prevalence, especially for children. If children are not losing valuable nutrients, they can absorb, or valuable nutrients to diarrhea, they can absorb them. This has a positive impact on nutrition and can have cognitive benefits for children. The economic benefits that can be achieved when women and children do not have to walk long distances to a water source directly impacts time savings, which in turn improves school attendance and household income generation. Adequate sanitation that is not far from the household, that's clean and safe, increases the general health and well-being of people worldwide. This in turn improves human dignity and social status. So the human right to water and sanitation, or the human rights to water and sanitation have transitioned from implicit responsibility to an independent right. In 1948, the UN Declaration of Human Rights declared that everyone has the right to a standard of living adequate for the health and well-being of himself and the family. The human right to water was recognized explicitly in 1972 in the UN Water Conference in Mar del Plata, concluding that all people, whatever their stage of development and their social and economic condition, have the right to access to drinking water in quantities and of quality equal to their basic needs. And then the collective right of all peoples would not be binding on states, but built agreement around the norms. And a series of international human rights treaties, such as the Human Right to Adequate Standard of Living in 1979 and the Human Right to Development in 1986, extended this explicit recognition of a right to water. So in 2000, the Millennium Development Goals set a target to halve, by 2015, the proportion of people without access to safe drinking water and basic sanitation. And the UN Committee on Economic, Social, and Cultural Rights sought to codify an independent human right to water through its 15th general comment. And this defined the scope and content of a human right to water and built upon the MDGs, the Millennium Development Goals for water and sanitation. So the Millennium Development Goal for water and sanitation is to decrease by half the proportion of people without sustainable access to safe water and basic sanitation. But the way that this is measured in the field is by measuring whether households have access to improved water or unimproved water. And improved water is defined as rainwater collection, piped water, a protected well, or a protected spring. Unimproved water is a river, an unprotected spring, an unprotected well, trucked water, or bottled water. So this improved and unimproved is a proxy for access to safe water. And when we look at coverage globally, we can see that the biggest challenge to access to improved drinking water is in sub-Saharan Africa. But what we have seen is drastic improvements in most regions of the world in water access between 1990 and 2011, largely because of the Millennium Development Goal for water. But unfortunately, improved water, as defined by the Millennium Development Goal, is not necessarily safe. So I have a nice photo that I took in Honduras of this very dirty water. It looks almost like the water in a mud puddle. And this water comes to households through a piped source every day. And this is what people have to use. So it's not so improved water is not necessarily safe, and it's not necessarily continuous. I have another example from a study I was conducting in El Salvador, and I interviewed a household that had access to water once a week. The water was piped to the household, but only for 8 hours, 1 day a week. And so they have to store that water in large containers all throughout the house, increasing the susceptibility to contamination of those open containers. And then there's not always the necessary technical capacity to address the sustainability of these water systems. So I have another photo of a water treatment system in Ecuador, in the coastal region of Ecuador, that cost $1.5 million to construct, but 2 years after construction, it was no longer functioning, and this was largely because of lack of technical capacity. And then we have these very large global disparities, urban and rural global disparities. So you can see some of the statistics are that 607 million people in rural areas are without access to improved drinking water, but in urban areas, that's 130 million. If you look at sanitation in rural areas, 1,538,000,000 people are without access to improved sanitation. In urban areas, that's 291 million. So you can see these stark disparities in rural and urban settings. And this is also true, these disparities you can also see amongst wealth quintiles. So if you look and divide countries or regions of the world by wealth quintile, the richest often have, in the richest 20%, have some of the greatest access to water, whereas the poorest have some of the least, the least amount of access to improved drinking water. So building upon the water and sanitation targets, commitments criticized for neglecting rights-based approaches to equity and development, General Comment 15 delineates the core obligation of a right to water and prescribes violations of these obligations and outlines a policy roadmap for states to progressively realize access to water and sanitation. And this is framed by overarching obligations to protect and fulfill the right to water. And General Comment 15 articulates discrete state obligations to ensure access to a minimum essential amount of water that is sufficient, safe for personal and domestic uses to prevent disease, and accessible, physically accessible, economically accessible, and that doesn't discriminate against individuals. So then the human right to water, adopted in 2010, built upon Comment 15. It was adopted by a vote of 122 to 0 with 41 abstentions. The General Assembly explicitly joined water and sanitation as a single composite human right, and this was a watershed moment, giving consensus to the substantive content of the human right to water and sanitation and the obligation of governments to respect, protect, and fulfill the right. So since the publication of General Comment 15, the number of states recognizing the human right to water has doubled. 41 countries have enshrined the right to water within their national constitutions or have framed the right explicitly or implicitly within national legislation. So as part of our research at the Water Institute at UNC, we facilitated interviews with key informants who work for national governments, international organizations, and NGOs. We facilitated 43 semi-structured interviews, and then 66 semi-structured interviews with local water operators and members of water boards and utilities in Africa and Latin America. And our question was about the implementation of this human right to water. So we asked 4 key questions. Are you aware of the Declaration of the Human Right to Water and Sanitation? Has the right changed the way you do work? What opportunities and obstacles exist at the international and national level for the implementation of the human right to water? And in order to implement this human right, what information do you use or need? So what we found was one quote, or a few quotes that I'll share with you, is from a government stakeholder. While the right to water and sanitation is in our Constitution, water and sanitation efforts are divided across a wide range of national ministries, and the roadmap to make reparation is difficult. And then from a prominent international water NGO, a quote is, "I think the UN resolution has changed the way we talk about it, water and sanitation, and get people mobilized around the way we do work." From a civil society representative, human rights efforts create political will from the top, but do not create much traction at the local level. So what we saw again and again at the local level was sometimes lack of awareness of the human right to water and sanitation, and then lack of knowledge about what to do if they were aware of it, and what it really meant. Does it mean we have free water? So what is it? What does it mean? A lot about awareness at the local level. So NGOs talked a lot about advocacy, how it created a way for advocacy, especially among local people, but that there was still lack of political will. And then when we spoke with local water providers, there was mainly a lack of awareness, but there was definitely expression of we have limited access to infrastructure and limited access to resources to access that infrastructure. And then national authorities commented on this incomplete information on populations without access. So who is it that doesn't have access? Where do they live? And then challenges of water scarcity. So the human right to water and sanitation has infiltrated our conversations, especially the future conversations around the post-2015 agenda. So a sort of process of reflection has been going on since 2011 to review options for the future sustainable development framework that will replace the existing Millennium Development Goals. And so there currently are working groups around water, sanitation, hygiene, equity and non-discrimination, and communications and advocacy in an effort to increase the goals, the number of goals, and because of some of the critiques that have occurred around the definition for improved access. And so the working groups have been formed with representation from practitioners from the North and South, academic, civil society, and are responsible for identifying potential global goals in their respective areas. And I'd like to briefly talk about equity and non-discrimination as this is a working group. So currently, this working group, and you can actually read the work of this working group on the Joint Monitoring Program's website, which is of UNICEF and WHO, and they have proposed a set of equity and non-discrimination targets. And what they've proposed is that you can disaggregate access by wealth quintile, by geography, urban and rural, by urban slums and formal urban settlements, and by disadvantaged versus the general population. You can determine a rate of progress for both the worst and best off in the country, and you can determine if the progress between the two groups narrows. Then you can rate countries by the number of groups of these four that they've reduced inequalities in. And so this is a suggestion. It's currently open for comment, but it's being discussed. So to close, the 2010 General Assembly resolution on the human right to water and sanitation presented a seminal international political consensus for implementing rights-based water and sanitation policy and addresses the most prevalent harms to health among the world's most vulnerable populations. While there remain obstacles to the implementation of this rights-based agenda, the UN resolution has created new opportunities to enhance global efforts to realize water and sanitation policy. Our challenge is to identify indicators that can be used at the global level to measure water affordability, accessibility, non-discrimination, outlined in General Comment 15. And then through these indicators, countries, leadership, states can be held responsible for specific targets that enable the fulfillment of the human right to water and sanitation. This will be critical as climate change, population growth, and water for food needs grow, increasing the demand on scarce freshwater resources.
Thank you. Would any of the panelists like to comment briefly on something when a different panelist said?
Thank you, Joe. Georgia, although we haven't met. How do you do? Thank you very much for those remarks. They're very interesting. I've dabbled a little bit in this area too. And what I've found is the problem is implementation. It's not so much adoption as actually implementing the human right to water. Then you have some countries, like my own, who have said it's not actually a right. And it, not only the United States, but other international donor nations, important ones. So while we have the General Assembly resolution, we have the Human Rights Council resolution. Not all states voted in favor of those. General Assembly resolutions aren't binding by as such anyway. But we certainly have a building consensus that people should have access, safe access to potable water. But my question really is, how do we approach the question of implementation when my state, California, which is what, the 6th, 7th, 8th largest economy in the world, depending on how France is doing, I suppose, has not realized this right for a number of agricultural workers in the Central Valley. You know, it's obviously our failure, our failing. But if we can't do it, how can we expect developing countries? Do you have any thoughts on that?
I think it's an interesting question that I've definitely thought about. I think the United States, I'll give the example of the United States because I've thought more and more about.
Get closer to the
microphone. The United States, as it has the resources to implement such a target or goal. But I think that it creates challenges that the country hasn't really thought about, as far as what do you do about migrant populations? What do you do about populations that live in very remote areas? It's extremely expensive to connect them. And what do you do about people who live? One interesting statistic that I read recently was that 1 in 20 Native Alaskans don't have access to basic water and sanitation. But some of this is because they live in areas where it's really difficult because of permafrost and freezing pipes to get access to these people.
Climate change is taking care of that.
Slowly.
I would like to see more advocacy and discussion around it in, for example, the United States and other developed countries. And then as far as, I would say, the research that we did, which was actually interviewing those that implement this, we focused primarily on Malawi, Brazil, and Ecuador. And we interviewed both national ministers, and then we also interviewed operators of water systems and managers of water systems. And it was surprising to hear in some countries like Ecuador, where the human right to water is actually a constitutional right, more people were aware of it. And though awareness didn't necessarily mean they demanded it, or that it translated into further advocacy at the grassroots sort of local level. So I think there's a lot of work to be done. There's progress that's been made. I think the human right to water, and especially the Special Rapporteur on the human right to water, Katarina de Albuquerque, has brought a great deal of focus to the human right to water and sanitation, and brought more attention to people about this as a pressing issue. So I think as a greater awareness is built, there'll be more and more discussion and talk, and then movement towards potentially making it a human right in certain places. But I think it's just really bringing attention to who has access and who doesn't, and why don't they have it if they don't have it.
Let me just make one comment as the chair, because I haven't really said much substantive so far today. And And it's about this idea of virtual water as some sort of legal concept, and I'm very dubious of that. Now, I sat in a restaurant in Jerusalem in December of 1993 while Tony Allen, literally on the back of a napkin, first formulated the idea of virtual water, and it was very exciting at the time. However, I've become very skeptical that it tells us very much. It's a way of alerting water planners, water decision makers, to the fact that you don't have to produce everything yourself. You can, if you have a shortage of water, you can import a lot of stuff, assuming you have the economic wherewithal to pay for it. But beyond that, I don't know what it adds. And I'll just give you one very immediate example. Several years ago, the 8 Great Lakes states of the United States entered into a new compact, which is fairly elaborate, but the gist of it is it's designed to preclude the export of water from the Great Lakes. Now, a colleague of mine at a different law school is working on a law review article. She asked me to comment on it. I'm not sure she's happy she did that, because the point of her argument was to allow the export of agricultural produce from the Great Lakes states is allowing the export of water, and that's banned by this compact. I think that's very unlikely that it has anything to do with the export of agricultural products. But this is where you try to treat virtual water as if it was real water, and it's not. It represents a real consumption of water, but what is produced is not water. But in any event, I'll let that go and open the floor to questions. Is there a microphone in the room? Otherwise, I may have to repeat. We'll start with Dan, because he's involved in some of this.
Dan McGraw from the Center for International Environmental Law. This is a question for Steve and Laurence, I think, and it's the easy question, or the obvious question. Now that we do think there's a human right to water, what does that do to the International Water Course Convention? When we negotiated that, we were not thinking in terms of the human right of water. And also, are there any of the regional basin agreements or basin institutions that have taken a rights-based approach? And if so, how is that working?
Shall we take, say, 3 questions and then answers? Yes? Rise and introduce yourself.
Valentina.
Well, try to keep it short. Try to keep it short, because I'm sure there are a lot of other people who want to ask questions.
Linked to that, I want to sort of reference Barton Thompson, the well-known Western question tied to that is water the next oil? If you believe it is the next oil, if you don't, let's just presume that you do, tied into that. In terms of the increased scarcity, increased demand, increased population growth, assuming you think it is, should we then go, scholars in this area, go one step forward to look at how to redefine the nature of water in terms of capturing what you mentioned, different varying interests?
Well, if I can...
Should we move ahead to redefine water as a non-renewable, in other words, clean fresh water as a non-renewable resource, as opposed to how it's being defined as a renewable resource? And then possibly...
Well, let's cut it off. I'm not sure how many people could hear her question. I think, at the risk of oversimplifying your questions, I think we can say that the first question she asked was about the geopolitical dimensions of water and water management, water disputes. The second question is about legal pluralism and what role it has to play. And the third question, and that's as far as we'll go, is about capturing the entire value of water and how you do that. Mm-hmm. All right, one last question right here.
Hi, Sharmila Murthy from Suffolk Law School. A question actually regarding the interplay between international water and thinking about the mutual gains approach or benefit, specifically thinking about joint fact-finding and the ability of states to actually share information when it's often maybe considered a national security secret.
Okay. Repeated? Okay. Again, at the risk of oversimplifying, a question about the problems of accomplishing cooperative water management in a world where water information is often treated as a national secret. And although those questions were addressed to specific persons, I invite all of the panelists to respond if they want to. Since several of them were directed at Steve, I'll suggest you go first.
Thanks, Joe. Human right to water and the International Water Courses Convention and regional conventions is what Dan McGraw asked about, asked of me and Laurence. It's a very interesting question to me because you do have this Article 10 that I think Laurence referred to of the Water Courses Convention, which says that vital human needs have to be taken into account in reconciling conflicting uses. What does that mean? Well, you know, you start drilling down into that, and of course, in the first level, you say, of course, you know, you can't resolve a conflict between two uses in a way that ignores vital human needs. But does it reflect a human rights approach? So you have a river and you have a boundary. And the question is whether we can apply concepts of human rights to a state on one side of the boundary, which is asked to protect the human rights of people on the other side of the boundary. Because, I mean, traditionally, that's not what human rights law is about. Human rights law is to protect me against my government, not Canada's. So we run into a little bit of a problem there. And you know, I've written things about this, but I haven't really resolved it. I don't think human rights law has gone that far, although there is some trending, I think, in terms of transboundary implications of human rights law. I'm not sure how well established that is now. Regional conventions, well, there's the Senegal River Water Charter that Laurence knows well as well. And in that kind of update of the Senegal River Agreement, there is mention, explicit mention, of the human right to water, which, you know, this is in a treaty between these states sharing the Senegal River. So, you know, for better or for worse, there it is. And all of these states and the Mekong River, the Senegal River Commission have to take this into account in managing their water resources. So can I pass it to Laurence?
Yeah, thank you for the question. I do feel that, I think that this human-based approach has taken grasp in the context of international water courses, and at the regional level, Steve has referred, for example, to the water charters that have been negotiated in Africa, the Senegal Charter, the Niger Charter, I think are good examples. There are others where really the focus is put on human needs. But so this is what I would call the substantial facet. But I think what is also important that more and more the concept of public participation is also taking grasp. And that means that when states are going to be evaluating, assessing their rights and obligations, they also have to consult with their populations. And the consultation with the population means that they will also be able to express their views about the, how the water course should be managed. Now, I have another reflection, and having recently written about that and looking at the strengths in terms of the law applicable to water, It's interesting to look at the Lake Llano case, because already there, the arbitrators felt that human needs of the people had to be taken into account. If you look at the decision of the International Court of Justice in the Gapshikovo-Najemo's case, also human needs are there when we speak of water. So it seems to me that it's no more possible to be interpreting the principle of equitable and reasonable sharing of water course without taking into account the human needs. And that's, maybe I have a question to the president of the tribunal, but in the Kishanganga dispute, what is interesting is that the tribunal referred to a specific provision of the Indus Treaty, which refers to the applicable law. Okay, and in this context, there is the treaty which finds application, as well as, I quote, international convention establishing rules which are expressly recognized by the parties, and customary international law. Now, this was very aptly used by the tribunal to give some space to environmental protection, okay, and to refer to the development of international law, and just to ground the notion of minimum flow and to give it a meaning. But the question that I would have is that if we've done that with, and the tribunal has done that with international environmental law, couldn't the tribunal do that also with some human rights obligations and norms? And that could also give a meaning to certain notions. And as I said in my presentation, so far the concept of minimum flow had been linked to the concept of human needs. Now, so if you give more and more importance to the concept of human right to water, you'll have to give a special meaning to this concept of minimum flow, because it also means water for the people who are depending about this access to water. So, open question.
My answer is, it's a pity you weren't a member of the tribunal.
You want to make a few comments?
Sure, thank you. Let me touch on the issue of water as the next oil. I really think it's a false comparison for a number of reasons. What's the criteria? Is it just because it's the next source of conflict, or is it because it's the idea it could be an economic good like oil, or is it as you suggested, the non-renewability aspect? I'm not sure these are valid comparisons. I do think that water as an issue is a major, serious issue. I'm not sure if I can compare to the value that oil and gas and energy sources have been in the past 100 years. I think it's bigger. I think it's a bigger issue, and I think it's a different type of issue. As a non-renewable resource, no, I don't think that will adequately address the water problem, though, as I see it, as I think many sees it, because oil and gas are non-renewable. That still potentially makes them subject to commodification, which I'm not necessarily against commodification, but I have I'm struggling with how to do it in a way that protects the nation's ability to protect its resources for its own priorities, because the idea of establishing global priorities, I think, is very challenging, except that I do have a suggestion, which I think might be a bit of a radical suggestion. Maybe this is where you were going with this, in terms of how do we conceptualize water, and this goes to the question of valuing water. We've done so as a property right, generally speaking. Even though it might be held by the nation on behalf of the public, it's still a property. There's an inherent economic value because of the way we treat water. Certainly in the United States, when we have water rights, it's usufructuary rights, but still there's a property value, economic value. And I think that has undermined our ability to capture all these non-economic considerations, the cultural aspects, the social aspects, religious values of water. And I think that I don't know if it's at all possible to completely scrap that model, scrap that system, and come up with what I would consider an ethics-based approach for water management, water allocation. So issues like stewardship, concepts like human rights and needs as opposed to wants. It's a serious shift in terms of how we perceive water. I'm not sure we can get there, but I do think that that the debate about the perception of water and how we value water has to be taken on.
Sure, I'll add maybe just one more comment about water is the next oil. Aaron Wolf from Oregon State did an interesting analysis where he looked at cooperation versus conflict over water, and he looked at all cooperation and all conflict, and he found that it was something, I'm going to get the numbers wrong, but it was something like 250 examples of cooperation as opposed to about 33 of conflict. And so there's this sort of many more examples of cooperation over water than there is conflict. That doesn't mean that there won't be more conflict in the future, but I do think that the past does demonstrate that in places where we might not be willing to cooperate over anything else, we've cooperated over water. And so it could be a source of cooperation rather than conflict, which is suggested by this water is the next oil. We're going to be fighting wars about it in the next. It's just food for thought.
Yeah, it's actually illustrated by the ability of India and Pakistan to cooperate over water and to arbitrate when they can't negotiate a solution, which, they don't arbitrate very many of their other disagreements. All right, I think we have time for at least 3 more questions. We'll start with Harold and then...
I think it's a shame to hear that kids are dying lack of water. So it's... And especially in coastal communities. And in the report of those schools, I said in order to have equitable and sustainable, we need a priority of users for drinking water and vital needs. If
Yeah. It is actually provided in Convention and in the Berlin Rules that vital human needs take priority, but...
And if we take this serious, now question to you, Stephen. I understood that, for instance, Israel is controlling more or less all the aquifers, but that the West Bank has more or less no access to drinking water. So imagine for a moment we could say this is a principle, not only no that private needs are important, no, that there is a priority. I mean, then it's not possible to solve this and to say, okay, can have access to water for agricultural or industrial purposes only after the priority use is fulfilled.
All right, thank you. Over here. Did everybody catch that question? Or he wants to know whether it would be possible to formulate a rule, I'm not quite sure how you would formulate it, that would say that Israel cannot use water for needs other than vital human needs until Palestinian vital human needs are fulfilled. Is that correct? Okay.
My question is to Madam Lawrence. Madam, you referred to that Kishanganga arbitration. The minimum flow, as the arbitrators have written, is not founded in the needs of the lower riparian. Because needs of both the states are already crystallized in the Indus Treaty. What the tribunal did, as I read in paragraph 85 of the final award, where they extracted paragraph 4 of the partial award, that the obligation to maintain the minimum flow is traced to the customary rules of the environmental law, which is read into the Indus Treaty. So it's not exactly the needs of the lower riparian which are appreciated or taken on the basis. It's the obligation to maintain the environment, that is flora and fauna. That's all the small clarification.
You want to repeat the question?
No, I'm just wanted, if I can, because it's something that I said at the end. I wanted to stress that. I think that in the environment...
No, my point is, it's not the needs which the tribunal took into account.
No, but I'd say it so at the end. I said so.
The obligation is traced to the international environmental law and into the treaty. That's how I put it.
Yes, and this was one of the great development of this award. Yeah.
All right. He's saying that the environmental and other obligations were read into the Indo-Pakistani Treaty on the Indus River by the tribunal, if I understand you correctly. One last question over here.
My name is Michelle Forsley. I heard a while ago that you can live
Actually, you can live longer without food.
Some of us can live longer. I work in the health sector where over the last 20 years, I would say, maybe a little bit longer, we have seen lots of changes when it comes to intellectual property rights and the treatment of commodities known as drugs as something that take on a different characteristic. And lots of laws have been changed and ideas are being floated from that environment, which I wonder how they apply in the water issue, which I believe will be much stronger and severe as the years go by. How fast we have to react to the water problems we will face much sooner than we had to act towards the AIDS crisis. And perhaps some of those lessons will help us going forward. And I'd like to hear if any of the panelists think or have thought about those lessons and the changes we have seen happen over individual rights, corporate rights, and the push towards corporate social responsibility, how any of that can help us going forward.
All right, if I understood the question correctly, and again, I'm going to simplify, whether the lessons that could be learned from changes in intellectual property law relating pharmaceuticals, for example, or other aspects of emerging doctrine about corporate social responsibility, whether those are lessons that could be applied in the water field. And again, I encourage any or all of the panelists to respond. Do you want to go first?
Yeah. I think Harold kindly put a question to me about access to water by the Palestinians vis-a-vis Israeli use of water, the same shared water for irrigation. And I didn't mean to say, Harold, that Palestinians in the West Bank don't have access to water, because Mccaffrey operates a very good and efficient water system, and to the extent you're connected to it and water flows through the pipes, you have access. You pay for it, but you have access. The Palestinians' concern is that they think they ought to be entitled to drill their own wells and control their own access to water. But you still have this disparity between the quantities of water available, liters per capita per day, as between Palestinians and Israelis. And yeah, I think clearly there should be priority given to especially domestic needs. But then, of course, you get into the question, how do you define domestic needs? And during the water courses negotiations, there was actually a statement of understanding adopted to that effect. And so domestic needs includes water for drinking, but also any water that is essential for the production of necessary food. But still, you know, we're not talking about a lot of water there, because domestic consumption, as probably we all know, is the lowest of all sectors of water use in all sectors, agricultural, industrial, municipal, whatever. Okay, so in short, I think, you know, you're clearly right. The question is, how do you go about implementing that? We have this implementation dilemma again.
Yeah. I should add, although I certainly don't have time to explore the full significance of this, but increasingly the Israelis are using recycled or so-called gray water in agriculture. So that changes to some extent the dynamic. And of course, Israelis are increasingly using desalinated water for their domestic supplies. So again, all of these technological innovations present, well, challenges might not be the right word, but opportunities is perhaps the right word. Opportunities for dealing with the shared waters differently than they've been dealt with in the past, but whether those opportunities be realized remains to be seen. Who wants to go next?
Let me just briefly address the question of corporate social responsibility. I'm actually doing a study on pharmaceuticals in drinking water and the lack of regulation here in the U.S. And I've looked a little bit at what corporations are doing. And the two driving forces, the way I read the tea leaves, one is the evidence, the science. And so if the corporations don't see the scientific connection, of what we're alleging or what people are alleging, they have a hard time buying into that argument. So I think it's a lot easier argument to show that people are dying. People are dying of disease and having all these water scarcity issues. The other part, though, is the part which I think is harder, which is there has to be an economic incentive for them. There are some companies today that do have this social mentality, so good corporate citizenship mentality, but it's not the norm. The norm for most corporations is the bottom line, and unless you can create an economic incentive for them to be good corporate citizens, and I don't think we have to force it on them, but I think it can be done through the general public. There's social movements that can convince the corporations that they won't buy their products if they don't become more responsible, but also through regulatory mechanisms that you can make it more challenging for the corporations to be polluters, for example. So you have water pollution permits and some other criteria that, in a sense, force them to become better stewards and citizens.
Perhaps add a codicil to that. Corporations are responsible to their shareholders. We've got to get to the shareholders. We've got to convince them, right? Exactly. Exactly.
All right. We actually have exhausted the allocated time for the panel, and so I will quote from General MacArthur, these proceedings are concluded. However, I encourage you to come up to the front and chat with myself or the panelists. Thank you.